Good evening. Today is November 30th, 2021. This is the Standing Committee on Justice, and we'll meet at 6 p.m. in room 255 with the chair to be announced. Thanks, and have a good evening. Test 1 2 1 2.
Mr. Nesbitt has been nominated. Are there any further nominations? Hearing no other nominations, Mr. Nesbitt is hereby elected as vice chairperson. So this meeting has been called to consider the following bill, Bill number 3, the Family Maintenance Amendment Act. I would like to inform all in attendance of the provisions in our rules regarding the hour of adjournment. A standing committee meeting to consider a bill must not sit past midnight to hear public presentations or to consider clause by clause of a bill, except by unanimous consent of the committee. Prior to proceeding with public presentations, I would like to advise members of the public regarding the process for speaking in committee. In accordance with our rules, a time limit of 10 minutes has been allotted for presentations, with another 5 minutes allotted for questions from committee members. If a presenter is not in attendance when their name is called, they will be dropped to the bottom of the list. If the presenter is not in attendance when their name is called a second time, they will be removed from the presenter's list. The proceedings of our meetings are recorded in order to provide a verbatim transcript. Each time someone wishes to speak, whether it be an MLA or a presenter, I must first say the person's name. This is a signal for the Hansard recorder to turn the mics on and off. Also, if any presenter has any written materials for distribution to the committee, please send the file by email to the moderator, who will distribute it to all committee members. Thank you for your patience. We will now proceed with public presentations. For the information of the committee, I have received 2 leave requests from presenters tonight. Firstly, Ms. Lisa Mcconnell and Mr. Bradley Miller have requested that they be allowed to present together. Is there leave of the committee to allow this joint presentation? Okay, leave has been granted. And secondly, Mr. Paul Wiens, who is the 10th presenter on our list tonight, has requested that he be allowed to present third due to a prior engagement. Is there leave of the committee to allow Mr. Wiens to present third? Agreed? Mr. Wiens? Yeah, Mr. Paul Wiens. Is there leave? Okay, leave has been granted. Thank you. So I will now call on Jill Stockwell and ask the moderator to invite them into the meeting. Please unmute yourself and turn your video on. Okay. Jill Stockwell, please proceed with your presentation.
Thank you. Thank you for the opportunity to let me speak tonight on the importance of changing the Family Maintenance Act to not be discriminatory. I am proud to live in Manitoba, where citizens are able to come and directly lend their voice to legislation being considered. I hope in the true intent of the process that you will listen intently and make amendments required to make this legislation fully inclusive and do right by all the children and parents who will be affected by it, including parents with a surrogate involved, and making it clear that donors are not parents. My name is Jill Stockwell, and I've been on a long journey that has led me here tonight to be presenting to you. I'm here for many reasons, but the most important one is my daughter, Charlotte Jordan Ruth Maddox Stockwell, better known as CJ, who was born in August of 2018. CJ's other mom, Courtney Maddox, and I knew from the beginning that our path to become parents was going to look different than most. We knew it was going to be a costly route using reproductive methods. From the beginning, there was no doubt that we were going to both be parents of the child we were conceiving, even though the law did not see it that way. Knowing that the law would not officially recognize me as a parent was always present in my mind. A couple of months before CJ was born, we went to see a lawyer to see if we could get the adoption in place before she was born. We learned that we could not even start that process until after we had received her birth certificate, which can sometimes be a months-long wait. Not only was adopting my own child going to be an additional cost, it would involve a long delay for me as a parent waiting to legally be the parent to my own child. This also meant that I legally did not have any rights to my child while she was being born. I'm not sure how many of you have children, but I'm guessing most of you did not even think twice about the parentage of your children. I had many worries. I worried about what would happen if Courtney was unable to make decisions on behalf of her child. I worried, what if the staff did not recognize me as the other parent, along with many others? The day CJ was born, I went to the hospital full of hope and excitement, but that worry was still real in the back of my mind. I made sure I was ready, and I had a number for my lawyer just in case I needed them to intervene on my behalf. I was relieved when the hospital staff were ahead of the law and actively included me as the other parent. This became more important as the delivery went on, and it became apparent that CJ was in distress and needed to be born by an emergency C-section. I find it incredible that I had more legal rights over the embryo in the freezer than I did the day my daughter was born. I also had to relive this fear when I had an unexpected medical situation that resulted in an emergency 8-hour surgery that they were not sure I would survive. I can remember thinking that we had not gone to court yet, and I was worried that CJ would be challenged on survivor benefits. These are worries that no parent should ever have to face. For most of you, November 9th is probably just another day, but for me, it is a day to be celebrated. It was on that day in 2020 that I was legally announced as CJ's mom by the Chief Justice Joyelle. So yes, good things did happen in 2020. I've not been able to put into words the emotion I felt that day. I had not prepared myself for how moving I would find it. This is something I'd always known, something all my family and friends had known. It was something CJ never questioned, and here it was finally being proclaimed for the law to recognize it too. I was CJ's mom and always had been, and even though nothing was going to change in my day-to-day life, no one could ever dispute again that I was CJ's parent. Most parents get to take this for granted, but for parents like me, that was not the case. Since that day, I've had many parents and soon-to-be parents reach out. I've listened to their excitement about expecting children and their worries that had not been fixed for them that day too. To all of them, I said, by November 9th, 2021, you too will have the same rights as me to be a legal parent. But boy, was I wrong. I thought that when the court ordered something, you would have to do it within that time frame. I thought this was so important to so many families. How could this not be a priority to address? I'm not sure why the court order date was ignored, and I'm not sure why the request for the extension came so very late. It felt as though this was totally forgotten and remembered when it was a little too late. 7 sets of 2 SLGBTQ plus parents brought the Constitutional Court challenge, and yet there was no mention of 2 SLGBTQ plus parents in any of the government releases. I'm curious why that would be. It also seems as though the legislation is moving extremely fast now, preventing some important conversations on the content, like ensuring that it is stated that a donor is just a donor and is not a parent. It was introduced on Thursday, second reading on Friday, and now here we are tonight, Tuesday at committee. So clearly it can move quickly, so why miss the November 9th, 2021 court set deadline? I hope that you will listen to the lawyers presenting tonight and take away their insight on what would enhance this legislation and show us that you want to get this right for all families in Manitoba. I would like to take a bit of my time to express gratitude to Lisa Naylor, her family, who built the foundation that we were able to build upon. They fought and won the right to have same-sex parent adoption. They had the courage to do this at a time when 2 LGBTQ plus rights were not considered to be human rights, and faced many fierce attacks for fighting for the rights of me and others. Their groundwork is what allowed us to come before you tonight, so I thank them for that. What can I even say about our amazing legal team? Robin and Roni from Taylor McCaffrey, Alison and Byron from the Public Interest Law Center. I always knew that they were just a call away and would talk me through anything we needed to. I will think often of you in the years ahead, and especially on November 9th, because you're the ones that helped make this happen for my family. I might even celebrate every year with rainbow donuts. That's still to be determined, but I know where CJ's vote will go on that one. To the other 7 sets of parents who joined us, I'm forever grateful and will share a very special bond with you all. To all the parents who are still waiting for this to be fixed for you, I will celebrate with you on the day the legislation is passed and enacted. On many occasions, I have heard Minister Friesen say that the legislation, when it was written, did not intend to be discriminatory, and with him I agree. It did not know that assisted reproduction would become an option. Minister Friesen, you have the opportunity to amend the legislation to be discrimination-free based on today's standards, and that would include parents who use a surrogate. I hope you will do the right thing and take the advice of our lawyers presenting tonight. I encourage you to reach out to our legal team and talk to them about this bill, how this bill could be stronger. 10 minutes is not a lot of time for them to share their wealth of knowledge. The world is changing, and I am able to say that from personal experience. The growth of 2S LGBTQ+ rights within my lifetime has been immense. My hope is that the next time discriminatory legislation is discovered, it should be dealt with as though it affects your family. Thank you for allowing me the time to speak to Bill 3 and the important legislation for my family. Thank you.
Thank you for your presentation. Do members of the committee have questions for the presenter? Minister Friesen.
Thank you, Joe, for being here tonight and presenting to the committee on this bill. I really appreciate it.
Thank you.
Ms. Fontaine.
Miigwech, Jill, for your presentation and for all of the courage to you and all of the other parents who came forward to make Manitoba a more equitable, inclusive, representative province with this legislation. And I know that the Minister, Cameron Friesen, wasn't listening to your whole presentation at the very beginning and isn't listening now either. So, you know, I want to apologize for the Minister in the beginning of your presentation. He clearly wasn't listening and was having side conversations with his staff there. But I want you to know that those of us on this side of the room, and actually his colleagues as well here, we're listening very intently. And, you know, what you did was beyond courageous and beyond proper and beyond right. And the consequences of that will be transformative for years to come. And so I'm really blessed to know you. For the purposes of our conversation here, Jill is actually a St. John's constituent, and I feel really, really blessed to know you. And again, I just want to lift you up for the work that you did. Just a quick question. I know that we're going to be hearing from your lawyer and how the legislation could be strengthened. But if you wanted to maybe take a little bit of time and say, maybe share with the committee how you would like to see the legislation strengthened.
Ms. Stockwell?
My apologies. Sorry, I should listen to the instructions at the beginning. I think one of the most important pieces is to ensure that donors are just donors and that it's clearly reflected in the legislation that they're not parents. And I think that needs to be very well spelled out. I also think the section on parents who use surrogacy needs to be strengthened quite a bit. I'm not going to try to explain it as well as other people can, so I'm going to leave that to them. But I do believe that those are two sections that really need to be looked at. And we have an opportunity to get this right for all families in Manitoba.
Mr. Gerard.
Thank you so much, Jill, for all your efforts on behalf of yourself and on behalf of others to try and get this legislation really as equitable as it possibly can be. I had one question for you in the discussion in the clause 24.25. It says a surrogacy agreement is unenforceable in law. And what that sort of implies is that the agreement can be broken without impacting, without breaking the law. And it seems to me that the message needs to be clearer than that, that the where you have a surrogacy agreement, that has a major standing, even though it may not be something that can be enforced in the law in a normal way.
Ms. Stockwell.
I definitely agree that the surrogacy section needs to be strengthened quite a bit to ensure that everybody's protected in it. And I'm going to leave that discussion more to the people who know a little bit more about that. My process didn't involve a surrogate at all, so I'm not as familiar as that path. I am more familiar with the donor path because we did use a sperm bank for ours. And I want to ensure that the legislation clearly reflects that a donor is not a parent.
Ms. Cox.
Say thank you so much for sharing your story. I know it's not easy, and you've been through some challenging times, but so very happy to hear that that little child in the back, we could hear all the little noises in the back, so it's wonderful, and God bless you in the future. Thank you.
Ms. Stockwell?
Thank you very much. I think CJ was trying to bust in to meet all of you as well.
Are there any further questions? Okay, hearing none, thank you very much for your presentation. I will now call on Robin Kazina and ask the moderator to invite them into the meeting. I would ask that you please unmute yourself and turn on your video. Ms. Fontaine.
Miigwech, I have a leave request to allow the distribution to allow the brief that's about to be distributed to the committee from our next presenter to be included in Hansard.
Okay, it has been requested by Ms. Fontaine that the submission that we have in front of us on the next presentation be included in Hansard. All agreed? Agreed and so ordered. Ms. Kazina, thank you for being so patient. The floor is open for your presentation.
Thank you very much. It truly is an honor to be here and speak to the Honorable Committee about this bill, and thank you for this opportunity. I'm Robin Kazina. I'm a lawyer. I'm a partner at Taylor McCaffrey. I'm a lawyer in Manitoba that has a substantial practice in fertility law, and I've had the privilege of working with a number of intended parents, surrogates, and donors throughout the years. And I can say through my work with those clients and with Manitobans, it became clear to me that we could do better to strengthen the law in Manitoba for children and families. We've been left applying laws on who is a parent and who is not a parent that had not been updated since 1986. So myself, along with Ronnie McKenzie and the Public Interest Law Center, Alison, Fensky, and Byron Williams, partnered on bringing the constitutional challenge, JAS versus Attorney General of Manitoba, that was heard last year. And firstly, I want to say that there's many positive aspects to the bill, and it has gone a long way in changing the law for Manitobas, and I want to commend that. And I want to express my support for the bill overall. However, I do think that there is very amendments that are necessary that would strengthen the bill and actually put into practice what the intent of the bill is. I've provided a handout with a summary of 8 points that really highlight 10 suggested amendments. And my intent today, due to time, I will only focus on the ones with respecting surrogacy. But I do want to clarify that none of the amendments that I am proposing changes substantially the bill. It makes, all it does is provide more certainty to the process, given that the government chose to implement a court order model for intended parents in surrogacy to be legal parents. So, high level, the essential amendments in my view are contained are the items number 1 and number 2. And what those amendments would do is confirm that court orders from when surrogate signs a consent from day 2 would need to be signed on an expedited manner. It would make sure parents get that birth certificate that they need to show that they're parents within an expedited and timely manner. And it would ensure that there is a streamlined process for these court orders to be made, which is the intent and provides security to children. So I'm just going to provide a little bit of a roadmap on an explanation of surrogacy for those who don't have a lot of experience. We have an altruistic system in Canada. It's all of the surrogates are acting altruistically. We have a federal act called the Assisted Human Reproduction Act, which makes surrogacy, surrogates cannot be paid like the states. Surrogates in 90, I would say 8% of cases do not have a genetic connection to the child that they're carrying. And there's many reasons why people need surrogates, and varied clients I have. Many women cannot carry a child because they're a cancer survivor. Many women cannot carry a child because they have a health issue. And of course, this also affects gay men who also cannot have a child other than the use of a surrogate. So how surrogacy would fit under Bill 3 is that the people who are actually this baby's parents would not be their parents until they get a court order. That's unlike other provinces. So BC, Ontario, and Saskatchewan all may ensure that the parents of the baby are recognized as the legal parents upon the surrogate providing the requisite consent. That is not the situation under Bill 3. Intended parents will need to get a court order, and then they will need that court order to fix their birth certificate. What will be happening under the bill, if it is passed as proposed, is that surrogates will be going on the birth certificate as a mother, and only one parent can go on as the other parent. So parents will have to choose which one of them is going to go on. And in that meantime, between that birth of the baby and day 2 with the surrogate signing consent and the order being made, one parent does not have any connection or recognition to their child. And not only that, the child has somebody on their birth certificate who's not caring for them, who's not genetically related to them. And this can have real implications on what that means for people practically. People need to make health decisions for their child. People need to get a medical card. People need to apply for parental rights. This can have an implication if intended parents were ever to separate in that interim period, if one of them were to die. So what we're trying to do is provide certainty to Manitobans that these orders, recognizing them as parents, will be done in an expedited and timely way for all of those very, very important reasons. I mean, my submission is that the government has a clear interest in ensuring and providing clarity on these matters and avoiding future court applications and future constitutional challenges. And it also ensuring an expedited and streamlined process also ensures that we don't use up the court's resources unnecessarily and we achieve proportionality. So now I just want to turn to the two areas of amendments on my handout that are numbered number 1 and number 2. All I am suggesting is that there be a clause in 24.1 sub 3 that it be added that these orders are made expeditiously. This is similar language that already is in the FMA for other types of orders. This is not something novel or new. And also ensuring that the process is such that the surrogate isn't overly burdened by having to participate in a court process after birth, when I can tell you, and I know you'll hear from some surrogates today, they do not want to be legal parents to these children. In their interest, they want to ensure that they are not legal parents as fast as possible and in a timely manner after birth. The second, number 2 amendment that's labeled number 2, that I would suggest to make this legislation stronger and actually achieve what is intending, is to ensure that once parents get that court order, that they get that birth certificate reflecting them as parents. Remember, they're only going to be having a birth certificate with a woman who's not caring for that child and one parent. So it's essential that there be direction, in my view, that there should be some legislative direction that the vital statistics amend the birth certificate only in these types of applications expeditiously. Now, I know I'm running out of time, but I will just highlight my other suggested changes to make this law stronger and really to protect children. There's basically number 3 to 6, which I've highlighted. One is ensuring that it's not easy to set aside these orders because these orders are only declaratory orders, and I'm advocating that there should be leave of people who are trying to set aside these orders. This is similar to the Divorce Act, where non-parents have to get leave. There should be some presumptions of parentage and decision-making from day 2 to court order. There should be stronger language that a donor is not a parent. And a surrogate should also be able to apply for an order. If she wants to be the one to apply that she's not a parent, she should also be able to apply under section 24.1. So essentially, in my view, none of these changes are changing anything significantly. We have been operating in a vacuum without legislation until date, and we need the certainty for families. It needs to be, and children deserve it, and it's the way to protect children who are the most vulnerable in these circumstances. Thank you.
Thank you very much for your presentation. And just before we open it up to questions, I just want to just bring us back when the first presenter was on. I erred in not following up on a comment that was made. At committee, we must refer to members of the committee as Miss, Mrs., Mr., or Minister, okay, not their first names. Okay, so thank you very much for that. And the floor is now open for questions. Minister Friesen.
Thank you, Mr. Chair, and thank you, Robin, for being at committee this evening. I just want to take the opportunity to first say I think it's unfortunate that the member for St. John's took the first opportunity to make the microphone to somehow spread information that's not correct. Even in my office and listening to these proceedings with an excellent audio and video.
Minister, just sorry to interrupt. I'm wondering if you have a headset or something. We can hardly hear what you're saying. And I understand a headset was delivered to your office, so that would be great if you could put that on, and that way we could have better clarity in the meeting room here.
How about now, Mr. Chair?
No, it's not very good at all. A headset would be great if you could, please. So while we're waiting for the minister to get a microphone or something, any other questions while we wait? Ms. Fontaine.
Miigwech, Chair. Miigwech, Ms. Kazinza, sorry, I apologize. I just butchered your name. I'm fully aware of that. I apologize. While the minister is figuring himself out, I would like to give you a little bit more time to, because I know that we don't have a lot of time and there are other amendments. And so I would like to hear about some of the latter amendments that you do refer to in your briefing here. If you could just maybe go through those a little bit more in a little bit more detail, if you don't mind.
Ms. Kazina.
Yes. The other amendments, other than the 2 that I focused on and kind of brushed over at the end, I'm assuming. The 2 really important ones are ensuring the expedited, streamlined process for everybody involved. The other amendments on 3 to number 6 in my handout is so declaratory orders can be set aside, and because there's nothing in this bill that confirms that intended parents are legal parents after surrogate signs consent, is it extremely important to make sure that nobody is trying to set aside these orders on a frivolous basis. That is unlike other legislation. Ontario, Saskatchewan, BC all confirm that the intended parents are the legal parents. And here, in this proposed bill, they are not the legal parents until a court order. And then secondly, that court order can be set aside. So I am suggesting that in these circumstances where people are obtaining orders in surrogacy, standard cases where all the checks and balances are met, where they have legal agreements, where they have independent legal advice, if someone were to come back and try to challenge that order, they should not be able to do that without leave of the court. And my analogy to that is in the Divorce Act amendments, a non-parent cannot just make an application for contact with a child. They are obligated to get leave. It's the same philosophy that intended parents should not have to, it should be a very high onus for these types of applications.
Ms. Fontaine.
Miigwech, for that additional information. I am curious, and I know that a lot of the recommendations that you are focused on this evening are in respect of an expedited process. And so I'm wondering if you can share maybe a little bit about, particularly for vital statistics, which we know are taking a long time for folks to get the paperwork that they need or the statistics that they need. Do you want to maybe share a little bit about how that kind of plays out in situations like this?
Ms. Kazina?
I can explain how things have been handled without legislation. Is that vital statistics has been accommodating, and so has the court, really, in trying to really make this work in a legislative vacuum, but it doesn't provide the certainty. So they do rush requests for birth certificates when it's a surrogacy birth, and the court does try to deal with it on an expedited basis, but there is no certainty. It's sometimes it's really quick, sometimes it takes weeks. It depends on the person working, and that's not, in my submission, a proper and predictable system for Manitobans. It needs to be predictable and consistent, and it shouldn't depend on the empathy or willingness or cooperation of a certain staff member. But people have been wonderful. I've experienced wonderful people at Vital Statistics, but again, it's a kind of a one-off, and there should be better certainty for people when parents are going to ask, after the birth of my baby, when am I going to get my birth certificate? When am I going to be declared a legal parent? When am I going to have that birth certificate with the surrogate off who's not caring for the child, and have both of us who are that baby's parents? And they need an answer to that.
Minister Friesen.
How are we now on your audio?
Much better, thank you. Go ahead.
Thank you, Mr. Chair, and thank you, Ms. Kazina, for being here and presenting this evening. I just wanted to briefly indicate, Mr. Chair, thank you for calling that point you did against the member for St. John's. I think it's unfortunate the evening begins with a false allegation that somehow in the minister's office on a remote channel we're not listening. I can assure all participants of this committee that in the minister's office, we have an excellent audio and video link to the proceedings. I have department officials across from me. If members of the committee or presenters see me glancing to the right, it's because that's where my officials are seated. And we have in front of us the materials provided by Ms. Kazina, and those deliberations at the table assist our presenters, and they assist these proceedings. So I feel like I should not have to clarify that for the member of St. John's, but I will do so because I don't super like the idea of false allegations on the record. Ms. Kazina, thank you for being at committee. We've written notes as we have listened, and we will, I'll be responding more when I make my comments on the bill later this evening. Once again, thank you.
Thank you.
Thank you for that, and we have run out of time for this presentation. Just before we call on the next presenter, I just want to reiterate the fact that the presentation from Ms. Kazina will be presented in Hansard. So with that, we will move on to our next presenter, Mr. Paul Bruce Wiens, and ask the moderator to invite them into the meeting, and to ask that you please unmute yourself and turn on your video.
Thank you, and sorry for the video here.
I first need to recognize you, so thank you for joining us this evening. Mr. Bruce Wiens, proceed with your presentation.
Brook Wiens, yes. Thank you. My name is Paul Brook Wiens. I am a resident of Winnipeg, Manitoba. My spouse and I were married in 2004, and for a while we did not believe that we would be having children. And when we decided that we would like to have children, it became very evident that it would be difficult for us without help. So we ended up going to Heartland Clinic for IVF treatments. For those who have been through IVF, it can be a daunting task and expensive. However, my spouse and I were lucky, and we had 2 children out of our 3 tries. Now, during this period of time, on our 3rd try, we had 3 frozen embryos that we were able to save in case we decided to have another child. We decided not to have another child, and through a friend of ours found out that their sister and brother-in-law were having difficulties having children, and one of the only ways that they might be able to have a child was through the use of a donor embryo. And so we decided to move forward with donating our embryo to this couple, or the 3 embryos. And fortunate to say that they ended up having a child on the 3rd try. 3rd try was a charm for them. What was interesting through the whole process was that we had rights to this embryo that we were donating to another couple. And it seemed wrong to us through this whole process that we should have any rights once we have decided that we no longer want to have another child. We had 2 already. We were not interested in having a 3rd. We were interested in providing this as a donation, and yet we still had some form of right to this donated embryo that could turn into a baby. And we never had intentions of being parents to this child. And so I want that specifically stated to this committee, that as an embryo donor, it was difficult enough for us to have children and to have to go to Heartland. For another couple that goes through probably a very similar situation, but they have to go to Heartland multiple times, sometimes 8 to 10 times, to find out that they are unable to have their own biological child. And then for another couple to show up, being able to donate an embryo, but the receiving couple being essentially told, you're not out of the woods yet. This donated embryo isn't necessarily 100% yours, must be extraordinarily difficult for the receiving couple to go through, because they might just have to cross their fingers and hope that a couple like us doesn't come back and try to claim some right as a parent to that embryo. That is my whole report.
Thank you very much for your presentation. Floor is now open for questions. Minister Friesen.
Still hoping this audio link is working well, and I see a nod from the committee chair, so I think that means all systems go. Paul, I just want to thank you for being at committee tonight, sharing your story. Appreciate this very much.
You're welcome.
Further questions? Ms. Fontaine.
As well, I want to say miigwech to Paul for sharing your story, and I know that that's not always the most easiest thing to share pretty intimate details with random strangers, and certainly in a car. So I do want to just say miigwech for sharing that with us and educating us here this evening. Miigwech.
Mr. Brook Wiens.
Thank you very much to the committee.
Mr. Gerard.
Mr. Brook Wiens, I think what you're telling us is that you would like amendments to this legislation so that it's very clear that when an embryo is donated, that the parents of that embryo are giving up the rights if that or when that embryo becomes a child.
Mr. Brook Wiens?
That is correct. Beyond the donation, there should be no legal parental rights to by the donors themselves.
Any further questions? Hearing none, thank you very much for your presentation this evening. I will now call on Rihanna Hawken from the Manitoba Bar Association and ask the moderator to invite them into the meeting. Please unmute yourself and turn your video on. Good evening, Ms. Hawken. Please proceed with your presentation.
Good evening. Thank you for including me this evening. I'm honored to be here. My name is Rihanna Hawken. I am a family law lawyer practicing with Dealey Fabry-Sellon, and I am appearing before you today as the chair of the family law section of the Manitoba Bar Association. I'll begin by stating it has been a tight timeline, being given only a few days' notice prior to the hearing. In the past, the family law section of the Manitoba Bar Association has been consulted on changes to legislation, and unfortunately, there has been no opportunity for dialogue or consultation on the bill. There may be important information and perspectives that are being overlooked as a result, and I would like the committee to be mindful of that as I make my submissions. I also want to preface my comments by informing the committee that assisted reproduction law is a specialized area of law and not something that family law lawyers face on a regular basis. Personally, it is not an area of law in which I have experience. Ms. Kazina has a vast wealth of knowledge relating to the subject matter, and I strongly support the comments that she has made, and as well as the suggested changes to the bill. I also wish to thank Ms. Kazina and Ms. McKenzie of her office for the enormous amount of preparatory work that was performed in anticipation of this hearing. As counsel practicing almost exclusively in family law, I do wish to emphasize to you the importance of this bill to Manitoba families, and in particular, the importance of having children's parents recognized in law from the moment of their birth. Legal parentage has a number of practical and legal ramifications to be considered, including but not limited to custody, parenting time, decision-making on behalf of the children, but also wills and intestate succession. So, for instance, in the event of a death of a parent. In the case of surrogacies, the bill as presented only allows one of the intended parents to go on the birth registration, which is problematic for a number of reasons. And as a lawyer, these are the things that come to mind just generally initially. For instance, what if the intended parents separate, or if they disagree with respect to medical decisions before a court order is pronounced? Which parent is allocated rights to make these decisions? Which parent would have custody of the child? How would the rights of the parents be balanced, and would the listed parents have more rights than the other? What if the listed parent dies prior to the order being pronounced, and then where does the surrogate fit into that framework when they are listed on the birth certificate? These are all scenarios that must be considered through the lens of the bill, and respectfully, it does fall short and leaves a gap there. And of course, the result is that children are left vulnerable without clear parentage in these situations. The structure and the intent of the Family Maintenance Act is to make paramount the best interests of children. The substance of the Family Maintenance Act and all other family law issues covered under the Family Maintenance Act are guided by these best interests, and this is really at the heart of the legislation. So to properly prioritize these interests, children require certainty as to parentage. The reality is that children are being born from surrogacy or other non-traditional arrangements. These children have the right to have their birth registrations properly recognized and reflect who their parents are, regardless of their circumstances of birth. This is the right of these children to clarity and certainty, and needs to happen as soon as possible following the birth. The courts have overwhelmingly recognized that legally recognizing a child's relationship to their parents at the earliest opportunity possible is in their best interests. Ultimately, the intent of the Family Maintenance Act is to protect children and serve their best interests. And while this bill will bring about significant positive changes for many families, there are still some concerns and improvements that could be made in the best interests of children, which is, of course, the guiding principle of the Family Maintenance Act. So subject to any questions, those are my brief submissions.
Thank you very much for your presentation. We'll now open the floor up to questions. Minister Friesen.
Thank you, Rihanna, for being at committee this evening and for sharing your views. And I have made notes as you've spoken. I appreciate you very much making the time to be here this evening.
Ms. Fontaine.
Miigwech, for your presentation this evening, and we appreciate you spending time with us and sharing and providing your expertise. Miigwech.
Mr. Gerard.
Yeah, thank you very much. Now, you've made the point that you think the parent should be recognized at the moment at birth, and this law, as it's designed, wouldn't recognize the parents until after there's consent on day 2 for surrogacy, etc. Are there other provinces or other jurisdictions where the birth is recognized at birth instead of waiting for this delay?
Ms. Hawken?
That's an excellent question. I do believe that there are, and perhaps Ms. Kazina, I do appreciate that she is no longer speaking, but I did have some extra time and I'd be prepared to cede that to her if necessary to answer. I do understand that because this is going to be, especially in the case of surrogates, order-based rather than, but I do believe that is the case in other provinces, but I don't know which one specifically. I couldn't tell you, unfortunately.
Any further questions? Hearing none, thank you very much for your presentation this evening. Next, I would like to call on, and I apologize if I don't say the name correctly, Alison Fensky from the Public Interest Law Center. I would ask the moderator to invite them into the meeting and ask that you please unmute yourself and turn your video on. And good evening, and I hope I said that right. Ms. Fensky, please proceed with your presentation.
Thank you. Good evening, honorable members. I am a lawyer with the Public Interest Law Center of Legal Aid Manitoba, and I'm co-counsel to 7 Manitoba families who successfully challenged the current Manitoba laws around parentage. The bill which we're discussing this evening comes as a direct response to that legal challenge, and I am appearing on behalf of our clients this evening. You've already heard from one of our clients, Jill Stockwell, who has so powerfully shared her story, as well as one of my co-counsel, Robin Kazina, and I'd like to build on those remarks. I want to begin my remarks to this committee by stating that the proposed amendments to the Family Maintenance Act are an important step forward in modernizing Manitoba's laws around parentage and in recognizing the myriad ways to be, to make, or to add to a family. These long-awaited modernization efforts are necessary, first, to ensure that the laws in Manitoba around legal parentage comply with the Canadian Charter of Rights and Freedoms, and in particular, the equality rights of 2S LGBTQ+ families who are overrepresented among the families using assisted reproduction. These efforts are also necessary to bring certainty to the legal relationships between children and their intended parents. And finally, modernization is also required to minimize the time and expense needed to have parental rights recognized in what is already a time-consuming, stressful, and expensive process for families who are using assisted reproduction. These were the goals of our clients when they started their legal action, and this bill goes a long way to achieving these goals, with one glaring exception, and that is in surrogacy arrangements. Other jurisdictions in Canada have chosen administrative models where the intended parents are recognized as legal parents and the surrogate is not a parent as soon as the surrogate signs a legal consent, without the need for either the intended parents or the surrogate to go to court and obtain an order. If it is the will of the legislature to go forward with a court model of recognition in cases where a surrogate carries and births the child, and if families are going to be forced to seek a declaratory order for one or both of the intended parents to be legally recognized, this process should bring as much immediate certainty to families as possible. And we believe there are 2 approaches to achieving this. One, there should be a presumption of parentage benefiting the intended parents after the 2-day waiting period has elapsed and once the surrogate has consented. Nothing in Bill 3 currently recognizes the rights and responsibilities of the intended parents once a surrogate relinquishes their rights as parent, but before the court makes a declaration in favor of the intended parents. What happens in that interim time period? For example, if a child is born and has immediate medical needs, who is the decision maker on day 3? Clarity is required, and these uncertainties can be resolved with a presumption of parentage. For example, in Saskatchewan, Section 62 sub 6 of the Children's Law Act states, after the child is 3 days old, their waiting period, the intended parents share the powers and responsibilities of a parent with respect to the child, and any provision in a surrogacy agreement that provides otherwise is of no effect. That could be a kind of clause to meet the intention of both sets of the intended parents and the surrogate while they are awaiting that court order. The second approach requires a process for seeking the necessary court order that is easy, cost-effective, and expedited. Parents and children need certainty in their family relationships, and they do not need to be jumping through the hoops of cumbersome legal processes in what should be some of the most joyful moments as a family, welcoming a new baby. Without a presumption of parentage in favor of the intended parents, there is significant uncertainty between the time parents apply for a court order and the time they receive a declaratory order recognizing their legal rights as parents. The court application process must proceed on an expedited basis without notice or utilizing the consent of the surrogate as notice to them, and without undue burden on the surrogate who's already consented to relinquishing their rights at this point in time. Once an order is made, the intended parents should be recognized as parents from the time of their child's birth, not simply from the date of the order. The expectation of an expedited process and streamlined process that minimally impairs the rights of the intended parents can be legislated. Without ensuring that the court processes in place are as simple and as expeditious as possible, Manitoba risks continuing the very harms that led to our client's constitutional challenge in the first place, the harms that were recognized as discriminatory and which were not reasonably justified in a free and democratic society. There are opportunities to ensure that any court processes used in surrogacy arrangements do not end up mirroring the onerous, expensive, and harmful measures that were found to discriminate against 2S LGBTQ+ families and which caused harm to any family using surrogacy, not just 2S LGBTQ+ families. I would like to conclude my remarks by recognizing the tenacity and courage of our clients. With their advocacy efforts, these 7 families are working to ensure that all families who use assisted reproduction have their rights recognized. I thank the honorable members of this committee for their time this evening and their attention to these matters.
Thank you very much, and the floor is now open for questions. Minister Friesen.
Thank you, Alison, for being here at committee this evening. My staff and I have made notes as you've spoken. I'll address the specific issues that you raised in my remarks later this evening. Thank you again for coming.
Further questions? Oh, sure, yeah. Ms. Hawken, would you like to respond to the minister? My apologies. Ms. Fensky.
Oh, thank you, Minister.
Ms. Fontaine.
Miigwech, Ms. Fensky, for your presentation. I'm curious about a couple of things. One, were you or your clients or your office in any way consulted with in the development of Bill 3? And then if you can share a little bit more, I know you talked a bit about a different model in a different jurisdiction, and I believe, I was trying to write it down, I think you had said an administrative order versus a court order. Can you explain that just a little bit more?
Ms. Fensky?
Thank you. Yes, first, to your first question of whether or not council or our clients were consulted in with respect to the development of Bill 3, no, we were not. With respect to your question about my reference to administrative models, yes, there is, there are two dueling ways of doing this in Canada right now. The court model, which is proposed in Bill 3, and an administrative model, which exists in jurisdictions like BC and Ontario and Saskatchewan. In those jurisdictions, the recognition of parentage comes through the use of consents and the birth registration process. And in that administrative process of registering the birth is when the recognition happens, because legal recognition is built into the laws that created that process. There is not a necessity of having a declaratory order in order to be recognized as parents. It's already embedded within the legislation, that recognition.
Ms. Fontaine.
So I would imagine that that administrative model would be significantly easier for new parents in you know, assigning a percentage or becoming parents. I imagine that that would be the easiest model for folks.
Ms. Fensky?
Yes, it is far more streamlined. It does not require the preparation of legal documents and the consultations with legal counsel in preparations for that application. Legal counsel would likely be involved at the outset in terms of the arrangements being made through the surrogacy agreement. So, folks who are using surrogates they're not without checks and balances in terms of agreements that are in place, the requirements for those agreements, the relinquishment of rights, and the independent legal advice that happens in order to protect both parties. But yes, they would not be having to go to court after the birth of their child in order to be recognized.
Ms. Fontaine.
Sorry, just one more question. So if you had been consulted, you or your clients, do you think that you would have recommended an administrative model or a court-ordered model?
Ms. Fensky?
Thank you. Through our clients' litigation, our clients were intending to have the harms that are caused by having to have the state recognize your relationship and your relationship to your child through declaratory orders after birth that have those harms eliminated, and to have an administrative model that would have been the hopes of our clients. Certainly, our clients recognize the need for modernization to this act, and this is an important step forward. But yes, had our clients been consulted, they would have been recommending an administrative model of proceedings.
Mr. Gerard.
Just briefly, I think you were aware of the amendments proposed by Ms. Casina, and in one of them, she wants comprehensive warning that a donor is not a parent. A donor could be a donor of an embryo. Is a surrogate mother also a donor by donating the reproductive material, in her case, the uterus?
Just before I call on that, we are out of time, but is there leave to allow Ms. Fensky to answer the question? Leave has been granted. Ms. Fensky, please go ahead.
I should clarify, there are some cases, while Ms. Casina did speak to, I believe she gave the statistic of 98% being gestational surrogacy, where the surrogate is not related to the intended, or to the child in any way. But there are surrogacy arrangements where the surrogate's own genetic material is used, so it is possible for a surrogate to also be a genetic donor in terms of their ovum. I don't believe that a surrogate is considered to be a donor simply by their participation in surrogacy. I believe surrogacy is a separate kind of act, but I would appreciate the opportunity to clarify that, if I would.
Thank you very much for your presentation this evening, and thank you for joining us. We will move on now, and I will call on Lisa Mcconnell and Bradley Miller and ask that the moderator to invite them into the meeting. I would ask that you please unmute yourself and turn your video on.
Oh, wait, here.
Good evening, and thank you for joining us. Ms. McConnell, Mr. Miller, please go ahead with your presentation.
Thank you. My name is Lisa McConnell. Joining me is my husband, Bradley Miller. We are much honored to be addressing this committee today, and we want to thank you for providing us with the opportunity to speak to Bill 3. Bradley and I are a married couple, and between us, we have 5 children and 6 grandchildren. And we have experienced firsthand the feeling of being a parent and the love and bond that you share with your child. In February of 2019, I began to think about surrogacy and if this was something I could do to be able to help others begin a family. I wanted to help individuals have families who might otherwise not be able to do so. I watched many of my own family and friends struggle with fertility issues, and I believe that everyone, no matter their sexuality or relationship status, should be able to be a parent if desired. I brought up this thought with my then fiance, now husband, and he was incredibly supportive. I then began to discuss the exciting opportunity with the intended fathers, and we began to grow closer than I ever thought possible. My husband and I began the medical screening process, and I was medically cleared to be their surrogate in the spring of 2019. Bradley and my wedding was planned for June 29th of 2019, and we had all agreed to wait until after the wedding to begin the preparations for transfer. Leading up to this, we had to ensure all legal requirements, more specifically, the surrogacy agreement was in place so that there were no delays after the wedding, as we wanted to begin the journey soon after. While going through the surrogacy agreement with our lawyer, we were informed that not only I would have to be on the birth certificate of the child, but because we were going to be married at the time of birth, Bradley would also have to be on the birth certificate. This caused much stress and worry at a time when we should have all been celebrating. We discussed at length with the intended fathers, and because we had built such trust between all of us, we decided to continue to go ahead. We entered into the surrogacy agreement before undergoing any embryo transfers, and in August of 2019, we transferred 1 embryo consisting of one of the intended parent's sperm and the ovum of an anonymous donor, which resulted in pregnancy. We continued to keep in regular and frequent communication with the intended fathers, and we communicated often throughout the pregnancy and in general spoke almost daily. They always made themselves available to speak with me following any pregnancy-related appointments so that they were up to date on their baby's development and progress. Immediately following the baby's birth, he was placed in the custody of the intended fathers so that they could bond and I could heal. Having to be registered as the mother and the father or other parent on the registration felt like a complete lie, and I really did not want to sign something that suggested we were parents to a child who is not ours and we never intended to be parents of. I wanted to cross out mother and put surrogate before signing, but was advised that vital statistics would not allow that and it would only delay the legal proceedings in recognizing the true parents and removing me. I was so uncomfortable with it that I handwrote birth in front of mother. We provided a supporting affidavit for the constitutional challenge that brought about this bill. In our affidavit, we stated, we hated the idea that for any period of time, even if it was a short period of time, we might be considered the child's parents and might be given the obligations and responsibilities that go along with that. We do not want to have any more children. We each have children who are adults now. At a time when I simply wanted to rest and recover physically from the birth, we had to sign significant legal work. And in our case, it took several weeks for the birth to even be registered by Vital Statistics. And the fathers were not even able to apply for a court order for some time. And all the while, we remained on the birth certificate. We are very happy that this bill addresses that the surrogate spouse no longer needs to be named on the birth certificate. And I also understand that safeguards are needed for surrogates, but I do not feel that this level is needed. I had a surrogacy agreement in place, and though I know it's not recognized by law, I felt very comfortable throughout the process. In any event, I just want certainty in the legislation that applications will be dealt with very quickly, and that it will not require significant paperwork and other time from surrogates immediately after birth, as we really just want to rest. I chose to become a surrogate, not because I wanted to become a mother or a parent again. I've already experienced that joy. I became a surrogate to give others the opportunity to experience that same joy. I don't feel that not being on the birth certificate is leaving me out of anything, but it is giving the true parents the peace of mind and rights they deserve. In any event, I just want certainty in the legislation that applications will be dealt with very quickly and that it will not require significant paperwork and other time from surrogates immediately after birth. Did you want to go ahead?
If you don't mind, Mr. Chairman, I'd like to say a few things.
Please go ahead.
As we mentioned, and that was mentioned in the past, with respect to the birth registration and birth certificate, and also an order for non-patronage, not only due to the fact that neither of us at any time were biologically connected to the baby, but it also brings awareness to the fact that it violates, I feel, and we feel, our rights and the baby's rights to confidentiality and privacy. Because it's an order that's registered within the court, it is accessible to the public and anybody else that would like to recover that information through whatever process the courts or the government has in place. So basically, anybody can, if they're going to do research or anything to that level, or journalistically, they can find out the information that myself and my wife, who have really no biological connection to a child, went through this process. In reviewing Bill 3, we have not seen anything which would address the potential of privacy or confidentiality issues for all vested persons involved. That's really all I wanted to say. And also I wanted to comment and expand on the fact that for a period of time, with myself supporting my wife through her journey of surrogacy, I was literally the legal father of a child that I had no biological connection to at all. That's all I have to say, Mr. Chairman.
Thank you very much for your presentation this evening. The floor is now open to questions. Minister Friesen.
Lisa and Bradley, thank you for being here this evening to share your personal story and your connection with this policy. We've listened, we've made notes. Thank you very much for attending. We'll be responding generally when I make my comments later.
Okay. Ms. Fontaine.
Well, Miigwech for your presentation. And again, like so many folks that have gotten up here and shared their personal journeys, it is quite extraordinary. So first off, I have to tell you that in the almost 6 years that I've been elected, I think that this is the first time that I've seen two people presenting and sharing that time and supporting one another to share what are, again, very intimate details and a journey that you took, a very selfless journey. And so I just want to lift you both up, but particularly Lisa, for making such like I said, a selfless decision to help folks become parents, which is, you know, many people's dreams to become a parent, and you helped make that happen. And so I really just want to lift you up for that. And then to share really the lived experience of what this actually looks like, right? We heard from lawyers this evening that talked about, you know, surrogates being tired and then having to deal with all of the legalities and signing paperwork and what that looks like. And then really to kind of map out for the committee that here are two individuals who are the legal parents and have no genetic connection to the baby at all. So I just want to say miigwech so much and just lift each and every one of you up. Miigwech for that.
Ms. Mcconnell, Mr. Miller?
Thank you. Thank you.
Thank you for your comments.
Mr. Gerard?
Thank you for an excellent presentation to give us all an understanding of what you have been through. My question is this. If it were possible to sign legal documents ahead of the birth, which would transfer parentage right at the time of birth to the real parents, the biological parents, would you think that would be desirable?
Ms. Mcconnell, Mr. Miller?
Absolutely. It would take away really a lot of the fears of the intended parents and give them the rights. You never want to think of worst case scenarios, but when there's a child involved, you have to. Us as parents, we never had to go through that. Who's going to make those medical decisions? Who's going to go on the birth certificate? And I feel like if that decision could be made before birth, it would just give everybody that peace of mind and allow them to be the true parents, which they are, but it would just be recognized.
And if I may add, we went through this journey and the birth of the child during COVID when it first hit. So that was other obstacles that it was important that we could have been called upon because we were basically legally the parents of the child. And with quarantine happening with the intended parents because they were from another province, it added into additional concerns. Mr. Chairman.
Thank you. Any further questions? Well, thank you again for joining us, and thank you for sharing your story this evening. Next, I would like to call on Lisa Davies Mcdonald and ask the moderator to please invite them to the meeting. And I would ask that you please unmute yourself and turn your video on.
Hello.
Welcome, Ms. Mcdonald. The floor is yours. Please proceed with your presentation.
Okay. Sorry, I'm very emotional. Hello. My name is Lisa Davies Mcdonald, and I'm speaking on behalf of myself and my husband, Rory Mcdonald. I'm a nurse and Rory is a plumber. In 2018, I was suspected to have uterine cancer. Within 2 weeks of hearing this news, my uterus was removed at the age of 28. This was devastating and traumatizing for so many reasons. One major one being that Rory and I had not had the opportunity to start a family yet. Thankfully, the doctors were able to keep my ovaries intact. For those of you who don't know, the uterus is the organ that a baby is grown in, and your ovaries produce eggs when mixed with sperm, make an embryo. The embryo implants into the uterus and a baby is grown. After sharing my health news with family, Rory's cousin, Sarah, offered to be our surrogate without us even asking. She felt it was important for us to have a chance at having a family, and felt this was something she could do for us. Sarah is not married, but has a child of her own who at the time was 9 years old. Once I healed from my surgeries, we attended Heartland Clinic, which is the only fertility clinic in Manitoba. I'm shortening the story and fast forwarding through a lot of timelines since I only have 10 minutes to speak. I cannot stress enough how long all these processes and steps actually took. At Heartland, we did IVF, which is in vitro fertilization, where they removed some of my eggs from my ovaries and inseminated them with Rory's sperm. They were then able to make 3 embryos that were 100% Rory and my genetics. We then had lawyers involved with Sarah, our surrogate, to draw up a legal document in order for her to be our surrogate. After one failed attempt, the second embryo was implanted into Sarah's uterus, and it worked. We found out we were pregnant with our daughter, Robin. Again, Robin is 100% genetically my and Rory's baby. None of our surrogate's genetics are involved. Robin is now 6 months old. Words do not describe how thankful we are for Sarah offering to be our surrogate, and how lucky we are that the IVF and implantation actually worked. This has been an extremely traumatizing experience for us. It still causes a lot of distress, as you can see. We had so many challenges with starting a family that most people will never experience or understand. This law, once passed, will make it a little easier for families like ourselves going through surrogacy. It is, yes, still horrible that my name is not on the birth certificate immediately at birth, but our surrogate's is. With this law, my name would be on the birth certificate of my own daughter in a timely manner, and hopefully with less stress and confusion involved. We relied heavily on our lawyers to do a lot of the work for us, as it was a very confusing process. It took about 5 months for us to finally get the birth certificate with our names on it. I don't think I need to explain how distressing it is to have someone else recognized as the mother of your own daughter. In a perfect world, my name would be on the birth certificate from the start. But this bill at least is a step in the right direction. By not having our names on the birth certificate, I was unable to apply for the child tax benefit, to have her name on my Manitoba health card, and any documents like social insurance number or passport. This whole process of IVF and lawyers to write up the surrogacy agreement and then, after birth, request us to be on the birth certificate costs around $30,000 or more, which thankfully we were able to afford, but many people can't. Anything to make this process easier and more streamlined is much appreciated. I am my daughter's mother, and I was the second that embryo was implanted into our surrogate. She is genetically mine, not my surrogate's, and to not be recognized as her mother for that period of time still causes me a lot of distress. I hope one day women who are unable to carry their own children are no longer discriminated against, as I have been. I don't think people realize the disadvantage women have when you can't birth your own children. I did not qualify for maternity leave, as maternity leave is for people who physically give birth. I only qualified for parental leave, which is significantly less time at home with your newborn baby. Because I didn't qualify for maternity leave, my workplace, the WRHA, did not provide me with maternity leave top-up. They would usually provide someone who births a child a 90% top-up of their EI benefit, which is obviously financially great. And I explained that I am caring for a newborn baby, and had I birthed her myself, I would qualify for this financial compensation. But they said they do not top up parental leave. So again, I'm at a financial disadvantage just because she did not come out of my body. In the hospital at our daughter's birth, we were considered guests, and we didn't even get a tray of food despite being in the hospital for 3 days with our daughter 24/7. And Sarah was considered the birth mother, but she was at home because she wasn't actually the mother of our child. Every time someone was speaking about our surrogate being the birth mother, it would make me fall apart. So again, if this bill will alleviate some of the stress that comes with this challenging journey, then that is a positive, and I support it. Thank you.
Thank you very much for your presentation. Do members of the committee have questions? Minister Friesen.
Lisa, thank you for being at committee this evening, for sharing your personal story, yours and your husband's. Congratulations on the birth of your daughter. We took notes as you spoke. We conferred at the table. This is very meaningful. Thank you.
Ms. Fontaine.
Miigwech, Lisa, for, again, like other folks who have spoken before you, for sharing such a personal details, and as you shared as well, like still very hurtful details, you know, again, to complete strangers. And, you know, I just want to congratulate you on the birth of your daughter, Robin. That's really good news. I know that we're all so happy here to hear that as well. And again, you know, I really do think it is an act of courage to come and speak to complete strangers and share very trying, hurtful, but also joyous